Tumelani sanibonani njani molweni afusheni thobela nda. Guys, today we are here with PVL3702 assignment number 1, 2024 semester 2. It's law for contract. And the due date is 19 August, which can be extended or not. Then there's the two cases that you may read for your own understanding. Then here is where we have a 10 marks, which is just a one question. I believe that you know this scenario. I believe that you have read the scenario. You know what's going on with the scenario. So I won't be reading scenario because I know that you have read the scenario and you have understood the scenario. So we'll start here where they say that Gloria approaches you for legal advice as she thought that she was signing for the cluster home that was next to the garden house at the entrance of the complex. And then the question is saying, apply the will theory and the direct reliance theory and advise Gloria whether she concluded a legal binding contract with Jack based on the written document that they both signed. For the cluster home described in the document, discuss fully and refer to case law in your answer. Do not apply CPA. Okay, so before you start answering the question, it's very much important that you know what is a will theory, what is a declaration theory, what is a reliance theory, which is based on direct and indirect. It's very, very much important. So we'll firstly look at this issue of a will theory, declaration theory, reliance theory, and direct and indirect theory. So reliance theory, these are based on the reliance theory. And then we'll start here with a will theory. Let's start with a will theory. Before we continue, you must not forget that this is an advertisement. The full videos are available under 100 joining fee on our channel. Support us so that we make more videos. Don't ask for document if you are not on our joining fee. Don't forget, law requires comprehensive research, and this channel is made for that. Okay, when we talk about the will theory, you must know that the basis of the contract is the will of the parties. And if one party's error is regard one of the vital elements of the agreement, there is no real agreement. The result is that neither party is bound and each party may reclaim whatever it has performed. In the light of the unsatisfactory outcome of this approach, there were suggestions that the theory will be supplemented. As will be shown later, the shortcoming of this will theory in the event of dissenters are corrected by the reliance theory, which we'll be talking about the reliance theory. So now what I wanted to show you here, before we go to this correctness of by reliance theory, is the definition of the will theory. You know, that the parties, the contract is based on the will of the parties. So it means that their mind must meet. So when we summarize, we can say that the will theory and consensus. Remember, will theory and consensus is one thing. The actual subjective here is that there must be a serious intention to contract. Is the same thing that I was explaining to you, and then that the parties' mind must meet, and then they must be aware of the material aspect of the contract, which they are. It means that even the identity of the parties must be the one that are contracting. Therefore, it means that if the third party, unless he has been authorized by the owner to contract on behalf of that person, you cannot contract with any person on behalf of another person's property. So the identity must be the one. So now we know about the will theory. We'll move to the declaration theory. Now let's talk about the declaration theory so that you understand. And according to this theory, the basis of an agreement is not the underlying will of the parties, but the will of the parties as manifested in their actions. This formulation was made by Vessel J. in the South African Railways and Harbours v. National Bank of South Africa, where the Land Judge of Appeal stated, "The law does not concern itself with working of the minds of parties to the contract, but with the external manifestation of their minds. Even therefore, it is from a philosophical standpoint the minds of the parties do not meet. Yet, if by their acts their minds seems to have met, the law will, where fraud is not allegedly, look at their acts and assume that their minds did meet, and that they contracted in accordance with what the parties purport to accept as a record of their agreement. This is the only practical way in which courts of law can determine the terms of the contract. This statement of the law has been criticized by various academic writers. Gray points out that Vessel J.A. did not apply this theory to the facts of the case before him. He suggested that it should not be followed in the future. That's one of the criticized. So I was just giving you some basics to understand about the declaration theory, because you must know the differences between the declaration theory, will theory, and reliance theories. Then now we know. Now let's talk about the direct reliance theory. Direct reliance theory is where the party is trying to escape liability with where the contract is not concluded accordance with the will theory. It means that that person will argue that the contract has been concluded via direct reliance theory. Direct reliance theory applies where one party leads the other party reasonable to believe that a contract has been concluded. There must be a reasonable reliance by one party believing that there is consensus. Requirements to prove for the application of the direct reliance theory was formulated in Sonap Petroleum case. On the other side, indirect approach is based on the Instuas error doctrine. Based on the Instuas error doctrine, where there is an agreement and one party indicates that valid contract was not concluded based on mistake, the party must prove that the mistake is material and reasonable. So there's the cases here which are here, and there's the reasonableness of the case which is based on Alien V16 Stalin investment. And then on the other material we have the Sona Petroleum, which was the case of the direct reliance. It means that will be summarized by these. These are manifestation of a contract because they formulate what the contract should be like, and this one is used to escape contractual liability. Therefore, Jack and Gloria will likely to use this one, these two, whether it's a direct or indirect, to escape contractual, or Jack will use this one or this one to escape contractual liability. So people will use these two to escape the contractual liability, and then they will almost use these two for the manifestation of the contract. Therefore, now we know, we have understood. Now let's answer the question. The reason why I wanted you to know about those indirect reliance declaration is because of how they ask question here. They say apply will theory and direct reliance theory. You can see, right? Okay, now let's open October examination 2023. If you can go to October 2023, let's try to go down very faster so that I can show you. Where is that question? Yes, this one. You can see that this question in Gloria and Jack is the same question. Whatever you can read here is the same thing. However, they differ when they ask here, because here they said that apply the will theory and Instuas error doctrine. Instuas error doctrine is indirect reliance theory, the one that I was talking about. So it means that on your assignment you apply direct theory, but this one on the examination they applied indirect reliance theory. So it's very much important to know all those so that you know, even though you go to the examination, you won't be confused. So now let's answer the question. In order to answer, firstly, you'll come and say question 1. Then you must start by defining what is a contract. It's very much important that you start by defining what is a contract. They said the notion of a contract Dale Hutchison et al. The law of contract has defined this contract as an agreement entered into by two or more persons with the intention of creating a legal obligation or obligations. This means that not all agreements between parties constitute a contract. A contract requires a serious intention on the part of the contractants to create a legal enforceable obligation called animus contrahendi. It means that you'll come and put the definition of the contract. Therefore, we have put the definition of a contract. It's time for us to move on to step number 2. As I have said, this is just an advertisement. The full video will be on the part or not on the part will be under Rand joining fee on our channel. You support us, then you watch the full video. Don't forget that the law requires comprehensive research, so you must not ask us a document if you are not on our 100 Rand joining fee. So for now, we paused, and if you want to watch a full video, you will find them on our 100 Rand joining fee. Don't forget that if you don't see a video, and don't forget that if you pay and you don't see a video on our 100 fee, please let us know on the WhatsApp 0619842135. And then 100 Rand fee allows you to watch all your written modules, assignments, regardless of the modules that you are doing. You will be eligible to see all your modules. So good luck, guys. I will upload the full video under the 100 Rand fee. Thanks for watching.